I am bringing you the first video blog of the new year from Whitcomb Selinsky. Whitcomb Selinsky is a veteran-owned and operated law firm in Denver, Colorado. Our focus is veteran-centric, and we do a lot of government contract work in our office. So today we're going to be talking specifically on a subject that comes up quite a bit in the context of government contracting, which is referred to commonly as the limitations in subcontracting. That regulation is governed primarily by 13 CFR 125.6, which is under the Small Business Administration regulations. The regulation was promulgated in June or July of 2016, and then there were several iterations of the rule that came out afterwards, but several that year, and then some subsequent modifications of the rule. The gist of the rule remains the same, which is was a promulgation of a rule in 2016. The law that gave way to the rule was passed by Congress and signed into law in January of 2013. And the point of the new rule was to shift the limitations in subcontracting from sort of an aspirational rule that was and remains in part governed by FAR Provision 52.219-14. And under the old rule, there wasn't much by way of enforcement. The old rule primarily focused on personnel cost and did not contain any clauses regarding similarly situated entities. So under the old rule, if you were a small business contractor and you submitted a bid on a contract that was a small business set aside, then the old rule required that at least 50% of personnel costs be spent by the prime, be spent on the prime contractor. The idea being that you wouldn't, as a small business, go out and win an award and then subcontract, the entire thing or more than 50% of personnel cost to another entity. Under the old rule, there was no allowance for subcontracting to another small business and still remaining within the limitations. But also under the old rule, there weren't a lot of toothy penalties for failing to follow that rule. The worst you were looking at under the old rule was negative CPARs, which is a past performance evaluation for your contract performance, and the measure of your performance under the old limitation subcontracting was the entire contract period. So theoretically, you could win a contract, submit a proposal for award, be awarded, and then subcontract 100% of the contract for the first 2 years or 2.5 years of a 5-year contract, take over and start self-performing in the second 2.5 years, and you could still remain compliant. Under the new rules, under 13 CFR 125.6, a couple of things have changed. One was, a big one is that it added a penalty of a minimum of $500,000 for violating the limitations of subcontracting. It's actually written, it's the greater of $500,000 or the difference between the 50% that you were allowed to subcontract to other similarly situated entities and what you actually subcontracted. The other important thing is it did add the language about similarly situated entities. So a small business awardee under a small business set aside can subcontract to another small business awardee and not violate the rule. The same thing with an 8A or an SDVOSB. Our firm deals with a lot of service disabled veteran-owned small businesses or SDVOSBs. So if an SDVOSB pursues and wins a SDVOSB set-aside contract and subcontracts to another SDVOSB, then they're not going to run afoul of 13 CFR 125.6. They'll be in compliance. But if that SDVOSB wins a contract and subcontracts more than 50% of that contract value to, say, another small business that is not an SDVOSB, then they could be suffering some pretty hefty penalties. The other thing that 13 CFR 125.6 does is it creates a time measurement. The measurement is the base year or the base period of performance. So not all contracts are awarded for a base year, but if it's awarded for a base year, then your timeline for complying with the limitations subcontracting is that first base year, that base period, whether it be 6 months or a year or some shorter period, you have to comply with it. And then each option year is a separate compliance period. It added the limitation, it added the similarly situated entity. It also, for the first time, dealt with the issue of independent contractors. The new rule under 13.125.6 specifically defines independent contractors for the purpose of complying with limitations subcontracting as subcontractors. That is, there is no language under the old rule dealing with independent contractors. Now there is. So if this becomes particularly sticky or nuanced if you're an SDVOSB that is competing for a VA SDVOSB set aside, because then not only does your subcontractor have to be a veteran-owned or service-disabled veteran-owned small business, but that company must also be registered in the CVE database in order for you to be compliant with the limitations in subcontracting. They can't be simply a self-verified SDVOSB who's verified on SAM. The other new addition to the 13 CFR 125.6 and limitations subcontracting is that it treats first-tier subcontractors the same as prime contractors for the purpose of compliance with limitations. So if you had the time and the energy to read the Federal Register when these rules were promulgated back in May of 2016, when the proposed rule was being promulgated, one of the things that the SBA and the FAR Council, or the SBA Small Business Administration, considered was, what happens if I'm a service-disabled veteran-owned small business and I go out and win an SDVOSB set-aside and I subcontract to another SDVOSB, CVE-verified SDVOSB company, and then they turn around and subcontract to a large company or to another small business that's not an SDVOSB. Well, the language in the proposed rule and the discussion about the proposed rule stated that prime contractors and first-tier subcontractors would be treated the same, meaning that the prime contractor is responsible for ensuring that their first-tier subcontractor does not subcontract out more than the allowable percentage to other than similarly situated small businesses, be it 8A, woman-owned, SDVOSB, what have you. And I don't know what I don't have any examples handy where that particular provision of the regulation is enforced, but it is something that the DOJ has taken a particular interest in. The U.S. Attorney's Office, rather, has taken a particular interest in making sure that prime contractors who are awarded are complying with these limitations subcontracting. Again, there's a minimum of a $500,000 fine associated. It's a statutory fine that was written into the statute in 2013. Again, it's designed to give this regulation teeth and to make sure that contracts that are set aside for small businesses or service-disabled veteran small businesses are actually benefiting the companies that they were designed to benefit. Now, there is one caveat within the first paragraph of the new regulation in 13 CFR 125.6, which is, if it's a small business set aside, total small business set aside, and it is beneath the total contract value falls below the simplified acquisition threshold, which is now $250,000. And it's a total small business set aside, meaning not an 8A, hub zone, woman-owned, an SDVOSB, or what have you, then the limitations of subcontracting do not apply, meaning that you can, if it's a total small business and you win that contract, you could subcontract, every dime of that contract to other than small businesses or to large businesses if you wanted. It may defeat the purpose of winning, but that's a business decision for you and your company to make, and there is no enforcement. But if it's a 8A, hub zone, or any other socioeconomic set aside and you win that contract, then you are going to be, it is up to the and the case law demonstrates that it is up to the contracting officer to enforce the limitations of subcontracting. But an important fact is that some cases have demonstrated that if on the face of your proposal, of your company's proposal, and when you submit your proposal to the government, as part of their responsibility determination, they should review that proposal to make sure that on its face, it does not violate the limitations in subcontracting. So if your proposal, for example, were to state that, we have the capabilities to perform this contract. However, our firm is only going to perform 30 or 40 or, less than 50% of this contract, then that would be grounds for a bid protest by a disappointed offeror who looked at, who had reason to believe that your proposal was not compliant on its face. It most often, I would expect it would come up in raising additional grounds for protest once the protester got their hands, or the protester's attorney got their hands on the administrative record and got an opportunity to look at your proposal. The other thing to keep in mind is that there are, paths around these limitations of subcontracting. The mentor-protege program, for example, allows that the protege in a mentor-protege relationship only has to perform 40% of the contract value if they are working in a joint venture with their mentor. That is one workaround on the 50% rule. But you should, keep in mind that, and the other thing is that the measure of work, whether or not the prime contractor is performing 50% of the contract value, is measured in dollars. So again, if it's a $1 million contract, there are some, and then typically in a services contract, the prime contractor, the awardee, would be required to not spend more than $500,000 of that $1 million on other than similarly situated subcontractors in the performance of that contract. Now, if it's a construction contract, as many of you already know, the rule is, and you're the general contractor, the rule is 15% for self-performance, and that's where the limitations come in. And in manufacturing contracts, it's 50%, but you're allowed to subtract from that 50%, or required to subtract from that 50%, the cost of materials for the purpose of manufacturing. So it's kind of a detailed formula for figuring that out in non-service related contracts. And a services contract, again, you can take out the hard cost of performance if there's hard cost associated with performance, and then the remainder, not more than 50% of that remainder, can be spent on other than similarly situated subcontractors. If you have any questions that are not answered by this video on the limitations of subcontracting, then of course feel free to reach out to my law firm, or to a law firm that you trust, or to an advisor that you trust on the issue of government contracting, and I'm sure they will be able to point you in the right direction. Again, my name is Joe Whitcomb, owner and founder of Whitcomb Slinsky. I thank you for your time and attention today on this video covering the limitations in subcontracting.